इंटरव्यू नहीं जो की है वो ना कॉपी करवा रहे ठीक है
गुड मॉर्निंग
ओके
Dear friends, colleagues, distinguished guests, I welcome you all to Lahore and thank you for your participation at this event. This event in the name of my mother and in her memory to honor her legacy for fighting for the rule of law, for gender equality and for justice. For my mother, the cause of justice was very dear, and the empowerment that comes with justice. She spent her life fighting for the vulnerable, the marginalized, the victims, the disadvantaged. And she was often the lone voice who, even during dark times, insisted upon constitutional rights, upon a restoration of democracy, and upon fundamental freedoms. Today is an event for my colleagues, mainly women lawyers from across the country. We have here lawyers from some of the more remote areas of Pakistan and from our other cities and marginalized regions as well. The event today is to discuss gender equality, the justice gap, and also this afternoon to discuss the criminal justice system of Pakistan and how it disadvantages women and victims of crime, especially women and children. We have here today as our keynote speaker Baroness Helena Kennedy from England. She is the director of the International Bar Association's Human Rights Institute. Baroness Kennedy is one of Britain's most distinguished lawyers. She has spent her professional life giving voice to those who have least power within the system, championing civil liberties and promoting human rights. She will be speaking about the challenges for women within and gender inequality and the justice gap. We then have Ms. Schona QC, who is the chair of the Bar Human Rights Committee and head of Cloisters Human Rights Practice Group in England. Ms. Jolly is renowned for her cutting-edge practice, pushing boundaries across her principal areas of practice in equality, employment, civil liberties, and human rights law, including international law. We will have a training session about treatment of vulnerable witnesses in civil and criminal trials and rules for best practice from Zimran, who is also from Doughty Street Chambers. Zimran is a human rights practitioner with a wide-ranging practice based around children law, mental health law, and international law. Our closing session for this morning will be from Her Honour Judge Khatun Sapnara, who is a circuit judge in England and Wales, and she is authorized to act as a High Court judge. She has sat as a judge in London, presiding over both criminal and serious family law cases, and she was instrumental in the creation and drafting of the Forced Marriage Protection Act 2007. I welcome all our distinguished guests to the stage, please, and to begin the sessions for this morning. Thank you very much. Last but not least, I will ask Mr. Kamran Arif to give some opening remarks for this morning's proceedings.
Thank you, ladies and gentlemen. It's a great privilege for me to welcome you on behalf of the Asma Jahangir Foundation and the Open Society Foundation to the first Asma Jahangir lecture on human rights. Asma Jahangir was not only Pakistan's best-known human rights lawyer, she was also one of the biggest names in the legal profession. And I think it's very important that we keep the memory of Asma Jahangir, the work that she has done for human rights and for the rule of law. I am mindful of the fact that we are running out of time. We are starting late, so I will not stand much longer between you and the eminent speakers. So I will end by saying that I look forward to 3 days of very happy conference activities. Thank you very much.
Good morning. As you already heard from Sulima Jahangir, my name is Helena Kennedy. I'm Baroness Kennedy, and I'm here from the United Kingdom. I'm a very old lawyer, as you can see. I've been practicing at the bar more years than most of you have been alive. And it's a great delight for me to be here today. And I want to say to Sulima, I knew your mother. She was a friend. When she came to England, she sometimes would come and to the House of Lords. We would have tea. We would look around at the grandeur, and we would say, what does this tell us about the state of the world? And we knew that it was a very far distance from the circumstances of most of our clients. She was a remarkable, remarkable woman, and she's a loss to us all and to the world. I used to say about Asma that that she was really in a class of her own. No one could meet her without being seriously impressed. And when we met, we would commiserate about the state of the world, about the slow progress on women's rights, and about the general urgency, the urgency that there is for us to challenge abuses of power wherever we see it. She and I always used to laugh and say that we were women in a hurry. And I think that we all have to be in a hurry if we want to see real change. She was iconic. She was a source of inspiration to me. I pay tribute to her today. Now, you have on this panel a number of people who in fact are all very well known to each other back in the United Kingdom. And I count all three of them as dear friends. Indeed, Zimran is a colleague in my chambers. It's lovely to be here on a panel of like-minded people. We're all here as lawyers who have worked in the justice system, in the court system, and now, of course, Khatun Sapnara has gone on to become a judge, and a wonderful judge, and has really sort of broken some of those barriers about taking women into places where they had not been before. We don't yet have enough women in our higher courts, although we may have somewhat more than you have. We now have 3 women on our Supreme Court. It took a long time for us to get there, but we do now have those 3 women there. It used to be that when I started at the bar, it used to be said by sets of chambers that they just didn't take women. They would say it very openly, we don't take women. And then we introduced a Sex Discrimination Act, which meant that it became impossible to say we don't take women. And then they would say, women, we've got one, as though having one was good enough. And at every turn we have to challenge those ideas that somehow they're doing, enough has been done on the equality issue for women by just having the odd woman here or there to make it look good. In the United Kingdom, this year, we are celebrating 100 years of women in the legal profession. I was asking some of my sisters-in-law here in Pakistan how long it was that for women to be practicing lawyers here in Pakistan, and I understand it would be perhaps around about the 50s, the 1950s, when women started practicing, and a small drift of women came into the law. Some of you may know your history and will be able to tell me. But in the years after women, after a great deal of battling and struggle to be allowed to study law and then to be actually become lawyers, that had been going on for 20 years more before it actually happened. It was a long struggle, first of all, to get women into higher education, and a great deal of exclusion took place with exclusionary rules. And what do you think it was that was said by the men in order to keep women out? They said the law is not suitable for women. Women don't have the intellectual capacity to be lawyers. The law is about rationality, and women are emotional beings. Women are all heart and no head, or something of that sort. And so those rationales were in there, sometimes explicit, and then for a while not explicit but clearly felt, and that women were not suited to it. And even when I started practicing at the bar, first of all in the 70s and then into the 80s, it was still very much this sense that if women were to be in the law at all, it was to be doing what was seen as being the women's area of law, that women should be practicing in the family courts and dealing with issues affecting children, or dealing with issues affecting women. And it's now, of course, a very different world, certainly in the British legal system. And women are in all areas of law. They're commercial lawyers, they're company lawyers, they're immigration lawyers, they're all sorts of intellectual property lawyers and media lawyers. They're in every field, not in great numbers in some of those fields, but the barriers by and large are being broken down. Why does it matter? And it matters because justice is fundamental in our societies. And law that does not contain many perspectives, that does not have the experience of women and people from minorities and a diversity within their ranks, then I'm afraid law does not develop in ways that will be sensitive to the reality of the lives of half the population. And I'm afraid, thank you. And I notice all you men at the back are clapping as well. I just want to say to the men at the back of the room, I count you as being allies in this business of changing the law. Certainly for me as a woman, having had male mentors, because when I came into the profession, only 6% of the profession was female at the English bar. And of course now it's a very different world. But at that time, you were a rare person in a seminar where you were being taught law, and there were so few women. But it was really by being given opportunities and a break by a male barrister who took me on as his pupil, by a very famous American lawyer who saw me in court and then mentored me when I spent time at his law office in New York. It was by spending time with successful men that who wanted to see women succeeding that I was able to build up the career in the law that I have had. So I say to you men at the back of the room, you have a responsibility in all of this. You are our partners in changing the law, and we have to do it together. By the end of today, you'll all be ovulating, you men at the back of the room. So I just want to talk about why it matters. It matters because women in the law bring a different perspective. It's very interesting. When Asma Jahangir and I used to talk about the law, and we would meet and we would eat very fattening cakes in London, we would always say, and it doesn't matter where you go, and obviously she had to be much more courageous than any woman in Britain in her field of law. She had to be so courageous because the circumstances were different. She was having to confront levels of violence and threat even to her, much greater than any of us have ever experienced. But all I would say is that we always used to remark on the fact that the world over, the problems were the same. The roots of the problem were the same. Law doesn't operate in a vacuum, and there's no justice without social justice. And while there is a great deal of disadvantage and impoverishment, then of course there will be some people who have difficulty getting justice before the courts. There also are the special ways in which women, and women perhaps who are from minorities, or women who are poor, suffer particular disadvantage. And the reason that we need women in the law is because perhaps having a different gaze, a different perspective, that can be brought into the law and help create change. How does law create disadvantage? You know, we can't all pretend that all law is just or that all law is administered in a just way. The underlying features which lead to the abuses of rights around the world are the same. Autocracy, people taking too much power to themselves and then abusing it. Patriarchy, the way in which our world has been configured around the empowerment of men, which creates often a sense of entitlement and the subjugation of women to a lesser status in our societies. Don't be kidded by the idea that is put forward, and it's put forward in all of our major religions, and it's put forward in all of our societies. The idea is, we put you women on a pedestal. You are special to us. You are too special to be given the role of being a lawyer or being a high court judge or a senior person in the judiciary. You're so special, we want to put you on a pedestal, they tell us. Well, all I'm saying is, don't believe it, because those are the words that are encourage women to remain in lesser positions in society and to accept the unacceptable. The absence of a free press in a society means that people also don't get to know what abuses are taking place, and they don't know what their rights are. The corruption of democracy, the ways in which in nations around the world democracies can be in name only, because democracy is about more than voting. Voting itself can be corrupted, but we also know that even with the opportunity to vote and to change our governments, we have to look at where real power lies. And we have to look at the ways in which a democracy requires more than votes, but also requires a free press, the opportunity for civil society to be active, and for there to be freedom to participate, freedom to associate, freedom to speak out. And so we know that there are many ways in which justice is undermined. The co-option of the judiciary. An independent judiciary is fundamental to the good society, to any good society. And once judges are taken off the bench because of the decisions they make, and I always remember the incredible spectacle that there was here in this country of seeing lawyers coming onto the streets in protest about what was happening to the Chief Justice here, was one of the inspiring things to the world, because that is one of our roles as lawyers, is to be protecting the judiciary and the independence of the judiciary. But we have to also be protecting our own independence as lawyers, and that without fear or favour we represent everybody, including those who might be seen by the government as critics of what they're doing. We are seeing at the moment the rise of populism all around the world, strongman politics, or politics where some lesser man is pushed up to the front, but there are darker forces behind them. There's a famous quote from Brecht: "Will there be singing in the dark times?" And the answer is, yes, there will be singing in the dark times, singing about the dark times. Sustainable development goals are very important. The United Nations has now a challenge, which is that by 2030, that we should be changing the way in which our world operates. And one of those goals is that we should be seriously championing the position of women and seeking to shift the parameters in the years going ahead. And I'm afraid if you have a look at a document which is referred to as the Gender Snapshot, and I suggest that you might find it if you look it up online. And I have it here with me because Pakistan does figure very clearly. But it points out that on the whole issue of gender equality across the Sustainable Development Goals, what we know is that more women than men live in poverty, especially during their peak childbearing years. We know that there is unequal power relations in households still that render women much more vulnerable to food insecurity, vulnerable to violence, and vulnerable in their birth givings, because so many women die still in childbirth around the world, and so many babies are born dead because of the problems women face in their lives. Women and girls less often receiving an education, All of those statistics are alarming about the condition of women the world over. And when it comes to Pakistan, there's a focus on Pakistan, and the inequality by wealth, location, and ethnicity is very important. And they speak about how that 40.6% of the poorest Sindhi women aged between the age of 18 to 49 living in rural areas are undernourished and suffer deficit because of issues to do with food. And that is in comparison with the richest urban Punjabi women. And we have to be very mindful of the inequalities in our society and the way in which they add to gender discrimination and to, in fact, accelerate and magnify it. In the United States now, so that you don't think it's only about your own country, which I'm now visiting, in the United States now, income inequality is at the highest it has been for 50 years, with the top 0.01%, not 1%, but 0.01%, own 20% of the nation's wealth. That's in the United States of America. More billionaires than anywhere else on the face of the earth, and yet there is very real poverty in the United States. We don't see it when we watch our televisions or movies, but that is the reality. And the further fact is that women the world over, in this growing difference, this differential between rich and poor, women end up carrying the burden of the greater poverty. I now, as you've heard, chair the Institute of Human Rights for the International Bar Association. The International Bar Association is the sort of, if you like, umbrella of bar associations around the world. There are 188 bar associations under that umbrella. And so it's an incredibly powerful and influential organization. I came to this role after many years as a practitioner, but also as someone who's worked within the legislature in Britain, because I'm in Parliament, I'm in the House of Lords. And I've also been in the world of education. I was the head of a college at Oxford and created an Institute of Human Rights with the law faculty there. And so my work has been across those different fields, making law, practicing law, and also in the study of law for new generations and how we can make new generations better informed, better lawyers, and lawyers who will not only seek to make a good living in the law, but will actually also be the champions of rights for individuals in all of our societies. And one of the things that I have learned is that law itself fails women the world over. And tomorrow we'll talk more widely about the problems with human rights having become a bad word, or a bad couple of words in so many nations. And the reason why, and be very clear about it, is because human rights is about challenging those who have power. And that's why governments often don't like human rights. And so never be taken in by the arguments that are made as to why human rights are not something to be embraced by societies. In the years of my work, I have looked at the situation of women in the law, and it was a very interesting thing for me to see recently the development of the Me Too movement. Now, whatever your views on the Me Too movement, it's been very interesting because women have been breaking the silence that there has been on so many subjects around the oppression of women. And the Me Too movement, of course, it starts in Hollywood and in places where we sort of had a good idea that this kind of abuse of women might take place. But we also have discovered that because women use the internet in order to raise these issues, we also had the voices of women around the world, not just in the United States or in Western developed countries, but around the world, women started using the internet to talk about their experiences of being sexually abused and harassed, about suffering domestic violence in their own homes, or suffering abuse within their communities or within their families. And they did so anonymously, but often naming those who had been their abusers. Now, I'm a lawyer, and like all of you, I believe in due process, and I feel very anxious about the cover of anonymity and the use of the internet to name and shame abusers. But the one thing that has come out of this very clearly is a recognition of the extent to which women the world over still experience the most atrocious high levels of violence and abuse. And that children too experience this, but particularly girl children. And what is interesting about it is that I see it as actually a critique of law. It's women the world over saying, our legal systems don't deliver for us. Our legal systems are not giving us the justice that we feel that we deserve. When we go to the police, having been raped and violated, the police judge us. They look to see whether we are a worthy victim. They look to see whether we are believable. And women's voices are believed less than the voices of men. The idea remains that women are the ones who are soiled and sullied by sexual violation, rather than attributing the serious wrongness to the man who does this. And often it happens you've got to recognize this, it happens where the perpetrator is not a stranger in the night, but actually someone known to the woman, someone known to the girl, and sometimes known to the child because they are in their families, their communities, their extended families, and so on. And there's a silence that has, for too long, weighed upon the people who are the victims of such abuse, and not enough a pointing of the finger and a deliverance of justice against those who are the perpetrators. We have to examine our systems of law. Much of the system that you practice here replicates and is very similar to how law was in the United Kingdom, dating back in time. Fortunately, because of the rise of women within the legal profession, there has been an examination of law. Women in the academy and in our universities, academics and criminologists have been examining whether the law itself, because it was never made with the input of women, with the perspective of women, is being delivered from a perspective that excluded that whole experience of women's reality. Recently, the International Bar Association, working in partnership with the Institute, conducted research around the world looking at how women professionals experienced practice, why it was that while there were growing numbers of women coming into the legal profession everywhere, growing numbers of women coming into the profession, very often they didn't survive in the profession into their middle years. Often you would see an attrition rate when women were in their 30s. What was all of that about? Was it simply the fact that women bear children, that they leave in order to have families? Is the profession unfriendly towards professional women? What was the problem? And so 6 years ago, the research was done to look at the position of women, and out of that initial research, there was a sort of a clear description of the way in which women's experience was very different from men, that the working world was created around a formula, which was that women, even if they had a profession, that they were the primary people with responsibility for children. That the working world of long hours as a lawyer was often very inimical and unhelpful to women as practitioners. And so we looked at all of that, but one of the things that came through that piece of research was that women received and were at the end of sexual harassment, inappropriate and unpleasant bullying and referring to them in sexual ways, and that women's experience was particularly gender affected them because of their gender. And that piece of work, the new piece of work, is called Us Too. And it's women lawyers saying, this happens to us too. We too, in the law, have inappropriate and undermining comment made on how we look, what we're like, and about us sexually, and inappropriate touchings, feelings, and ways in which we are abused, and sometimes even more serious than that. And it doesn't just happen in secret places, it happens everywhere. It's happening in the United States, happening in Britain, Australia, all around the world. Women, sometimes openly, but some more often than not, without giving their names, spoke about the ways in which they had experienced this in the workplace and how it could undermine their professionalism and how they were feeling about their practice. And so there needs to be opportunities for women to meet, to talk about this sort of thing, and to be finding allies amongst men, good men, decent men, about putting an end to this, because I'm afraid it does undermine women in professional life, particularly women coming in at the early stage, and it often can be the reason why women don't stay the course. But we also have to confront unconscious bias in the appointment of people to higher office. And I want to say to all of you, don't believe it when people say to you, but we only appoint on merit, as though therefore you can't be good enough. There are plenty of mediocre men being appointed to high office, plenty of them. And so you have to then ask the question, why is it that there are few women getting to those higher appointments? Why is it there are so few women in the partnerships in our law firms and in law offices? Why is it? And it's so often about people appointing people like themselves, about the underlying belief that somehow that women can't do it in the way that men can. And it isn't true. And the reality is that that closed shop that men had has opened up, but they still, in the interstices, still underneath the surface, they are being exclusionary. And often we find that the appointments are being made still by men in their own image and likeness. And they bring on young men, but they don't provide those opportunities for women to rise to higher positions in law firms or to be coming onto the bench. When you look at the criteria and so on, look and see, are the criteria really, really simply meritorious? Or who is it that are the gatekeepers? Who are the people who say whether you are meritorious or not? Who are the judgment takers in all of this? Recently, when we only had one woman on the Supreme Court, 2 new places came up. And I was pushing very hard to try to get those places filled by other women. And then I discovered that out of the 23 people consulted to give their views on who should be appointed next, of those 23 people, only one was a woman, the woman who was on the Supreme Court. And she complained about the fact that women's voices were not in there making the judgment calls. It was all the chaps appointing other chaps. And so I'm saying to you, really be cynical about the ways in which these things are done, call them into question, look at judicial appointments, and demand that the gatekeepers are diverse too. And I wanted to say to all of you, we have responsibilities as lawyers. The reason that we've come into the law, and I'm sure this is true of all of you, is because we want to play our role in making good law and delivering law well and justice well within our societies, because we know that it is one of the fundamental pillars. And to do that well, we have to know and understand the lives of the people we represent. And we have to also challenge assumptions that are being made. The stereotyping of women, that some women don't deserve to be protected. She's a whore, so who's going to believe her when she says, yes, but she was raped multiply by a gang of men? Why shouldn't she be believed? It has to be right that a woman can say no, and that it really does mean no. And it doesn't matter whether she's a whore or who she is. And it doesn't matter whether she slept with other people or not. And the consequence of it cannot be that she is the person who ends up being blamed and questioned in unacceptable ways in our courtrooms. You're going to hear from Zimran, and you're going to hear from Schona and Khatun about the practice of law and the development there has been particularly over the last 20 years, to try to help the courts understand domestic violence. That when women don't speak publicly or cover up, it's because of shame. Women are made to feel ashamed. They're made to feel as though they're the people responsible when they are raped. Really? They're the people who are made to feel responsible when they're battered by their husbands or other members of their male members of their families. Really? Is it ever acceptable to beat the hell out of a woman and to behave in that way? No. And we have to be making that clear in the courts when we're acting in the cases. And this is true of you as men as well as women. We need to partner on this and to say that our societies are too abusive of women and we're not going to let it continue. And the wonderful thing is that in Britain, these are no longer issues being taken up simply by women, as was the case when I was young. They're now being taken up. Men like Zimran, lots of our men in the law are actually the champions of these kinds of changes because it makes for a better world for men as well as women. And so I wanted to really just finally say to you, the Me Too movement was that basically women, a bit like the suffragettes saying women should have the vote, they were throwing bricks through the windows of our legal systems all around the world. They were saying, you promised us justice, but your court system is still not delivering it for us. And so we have to listen to that. And we have to be the people who make the system good. And we're living in times when, unfortunately, places that we used to look to and admire and think that they were making the headway for us all, are not. When the President of the United States can speak in such derogatory ways and in such disgusting ways about women, you know you're in serious trouble, and that he can do so publicly. When someone like Michael the Vice President, Pence, says that he would never be in a room on his own with a woman, even doing parliamentary business, even doing governmental business, what is it he thinks that Angela Merkel's going to do to him when he goes into a meeting with her? It is a nonsense. If we really want equality, it will only be achieved if we constantly call out the practices that sustain inequality. And we have to recognize that this business of thinking that law is neutral is that treating as equal people who are not equal in that old-fashioned way that judges would say they were doing just creates further inequality. If you don't acknowledge the ways in which society keeps people unequal because of poverty, because of gender discrimination, if we don't take that into account in our judgments and in the way in which we argue cases, you will never deliver justice. The law has a powerful part to play, and it's a job for men and women together. Change involves constant intellectual effort. But of course we all resist it because we like things to be the same. It's only human to cling to long-held beliefs. But we have to keep making the argument that this is about our shared humanity. This is about human rights, whether governments like those words or not. This is about justice, and we all are its servants. Thank you.
I'm going to see if I can speak from here, because I think my laptop will fall off the podium. Can everyone hear me, or would you prefer me to stand? I can. It's okay? All right. Well, first of all, thank you very much. I'm really delighted to be here in Lahore after maybe 14 or 15 years, and it's a pleasure to see so many women and also some men come to hear about how we can make things better for all of us, and by emphasizing the role that equality has in our legal system. I'm an equality practitioner in London, and I work both in London and abroad. And one thing I would, if there's one thing I wish to impart today from 20 years of practicing in this field, I want to say that the impact of discrimination and inequality in our wider society matters at the very doorstep of our profession, all of us are doing. It matters not only because we're meant to represent the societies that we serve as lawyers or as judges, but because we cannot be effective in seeking justice unless we ourselves, professionals working at the heart of this matter, understand both the nature and the depth of the challenges we face as a profession and that we face as part of wider society. But if the concept of justice seems simple and everybody intuitively understands what's fair and what's not fair, the concept of equality is, I'm afraid, much less simple. It is a difficult construct conceptually, and it's a difficult construct to be able to put into practice in our field of law. I'm asked today to address the question, the role of the advocate and judge in ensuring equality. And I'm speaking to you today in my experience as being an advocate, and of course we have a judge who will tell you her side of the story. But I want to talk to you what I, as an equality and human rights practitioner, both expect from my own practice and should and do expect from the judges in front of whom I appeal. So there are a few questions I want to address this morning. First of all, what do we actually mean by equality? Sounds easy, but how do we break that down? How does that become a legal concept that we can work with? 2, what is our role as advocate in ensuring equality? 3, how do we as advocates ensure that judges are considering equality? And 4, what is our personal responsibility as members of the legal profession, whatever our area of practice? For all of these questions, we have to consider the difference between 2 versions of equality. The first is a formal version of equality, and the second is a substantive version of equality, and I'll come to talk a little bit about what those differences mean. Equality is something that everyone aspires to. We find it in many constitutions, in most constitutions around the world. We find it in many treaties. But when we seek to pin it down, identify what it looks like, the concept starts to shift. Are we talking, for example, about equality of access to justice? Does everyone have the same right of access to a fair trial, for example? Are we talking about equal treatment by wider society, by the bench, and by our colleagues in our own legal profession? Are we talking about the substantive changes required to ensure that people, every person, is propelled onto a level playing field so that each of us can maximise our potential through our dignity as a human being? Are we talking about economic inequality? And finally, can you separate out any of these different concepts in the end? What are the characteristics that need to be protected and ensured? Today's conference focuses on gender equality, but gender doesn't stand alone as a potential disadvantage in our society. It's not the only characteristic we have to think about. We have to think about wider characteristics that intersect with gender that create such an imbalance. Intersectionality is a buzzword right now that people are talking about. What does it mean? It means we have to look at a whole person. Someone who comes to the table, a woman who comes to the table, is not just affected by her gender. She may be affected by her age. She may be affected by her disability. She may be affected by her minority status. She may be affected by her sexual orientation. She may be affected by all of those put together. And so we have to think about gender as one in a multi-overlapping concept of equality that needs that broad consideration. Ensuring equality as an advocate means we have to consider each of those factors. And when a client comes to our table, we have to be thinking about all the different ways in which she might be affected or he may be affected by that failure to access a level playing field, both formally and substantively. In most of the treaty principles internationally, equality is often described in formal terms. We see it in the Universal Declaration of Human Rights, we see it in the ICCPR. Coming from Europe, we see it in the European Convention of Human Rights. I just want to read out, as a reminder, what Article 2 of the Universal Declaration actually says. It says, everyone is entitled to all the rights and freedoms set out in this declaration, without distinction of any kind, such as race, colour, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Those key words there, without distinction. What that has been taken to mean for so long internationally is a formal version of equality. That means that your fundamental rights to have a fair trial, to privacy, to free speech, to free association, those rights must be treated in a way without distinction. So you can't have a worse access to court or a less free right to expression because you're a woman or because you have an unprotected characteristic. But as equality law has become more sophisticated and our understanding of what it means has become more sophisticated, gradually newer treaties, newer equality provisions in national legislation is beginning to understand that to offer that formal concept without distinction is not enough to push us into a place where we are truly equal. Now, what you hear about most commonly from the US are concepts of positive discrimination, but it is a concept that's beginning to find its way into legal provisions all over the world. So as an advocate, when you're thinking about how your client has been deprived of equality, you can't just think, has she had the same right to be able to produce or to give her evidence in the same way in court, or has she been the victim of sexist language or obviously sexist treatment in a way that's just so obviously a distinction between how a man would be treated and how a woman would be treated. You have to think about whether broader concepts in society actually stop us reaching our full potential. Are there structural barriers, not just a sexist comment, but are there structural barriers which prevent women or other minorities from achieving their full potential? To give you an example of what this looks like in practice, in the EU and in the UK, we have equal pay legislation. And so on one hand, it recognises formal equality. I, as a woman, have a right to be paid the same as a man who does like work, a concept that would be easy for everyone to understand. If I'm a teacher as a woman, I should be paid the same as a teacher who's a man. That's a straightforward, easy, formalistic concept to understand. But what happens if the majority of a certain profession are historically underpaid, are historically devalued, because those professions have been considered to be historically women's work? Think about cleaning, think about sewing, think about these industries where you see huge numbers of women being abused in a very broad sense in terms of their pay and their working conditions, etc. That formal concept of equality, do I get paid the same as a man, is not going to be enough to push us forward into a much wider concept, into a deeper level playing field. We need to recognise that is a structural barrier in society that we need to push over to get substantive equality. So the way in which that has been done is by recognising that if I do work, the concept legally is called work of equal value. But in terms of what it's doing is it's saying that the law recognises that actually there is work that has been labelled women's work. And it's no less technical or no less arduous than work that's been labelled, for example, men's work, is given higher status to. To give you a practical example of that, we have had, and I've litigation, 2 decades or so of litigation in the UK, where those concepts have been developed. So hospital workers, for example, we see cleaning staff, who are mostly female, being underpaid, and we see male porters, the ones who carry the luggage and move the beds, etc., being paid higher. And the courts have eventually decided, through this provision of substantive equality in the law, actually, we can't undervalue women's work because historically they were forced to do this lower paid work. We have to find a way to make that apply to everybody. That's an idea of how formal versus substantive equality works in practice. There are other ways in which equality needs to be broken down, and we need to think about different concepts. And I don't know what specific concepts you have within Pakistani law on equality, but in the UK and in the EU we have different concepts to be able to recognise the difference between formal and substantive equality. So you have something called direct discrimination, an easy case of a sexist comment or a racist comment, or simply excluding someone because of their sex or their race. And then you have something called indirect discrimination, which recognises those barriers. So, for example, women aren't allowed, in other words, everybody is allowed access to something in theory. The rule says in theory there's equal access. The reality is the way in which that rule is applied means there's a substantial disadvantage, or particular disadvantage for women or another protected group. Then, of course, there's harassment. And I wanted to take a moment to talk about the harassment laws because I'm aware that this week in Pakistan there has been an interesting decision in the case of Misha Shafi and Ali Zafar. And I'm aware that there's been a lot of controversy about this. It's even reached us in England. And I'm aware that there has been a big discussion about sexual harassment conducted through a social media campaign largely. But what I understood happened this week was that the case was thrown out of the court on the basis that sexual harassment is protected in law, or you are protected from sexual harassment in law if you are an employee. So it only falls within the employment provisions, but there aren't wider provisions to necessarily prevent that. And that's something that we were confronted with as well some years ago in the UK. How do you deal with this in a broader basis in society, not necessarily just through criminal, but are there other civil provisions? And in 1997, we adopted something called the Protection from Harassment Act, which also provides civil protection from harassment. So equality isn't something that's just dealt with in employment law alone, or in family law alone, or in criminal law alone. We have to think about how we adopt it in much broader provisions, civil provisions as well as criminal provisions, in education law, in access to goods and services law, and similar areas. So equality is an enormous subject, and one of the dangers as an advocate is allowing equality to be pigeonholed. Just like the women's work I was talking about, this is something that only affects women. And one of the great changes that I've seen in 20 years practicing as a barrister in London is that, as Helena said, there has been a shift where we now see men and women fighting for the same things, and it's very important. We're very far from perfection ourselves, but it's very important that we as women have allies in the other half of the population. We can't just do it on our own. So we need to bring everybody with us. Now, one of the reasons why that's important is because if we're sitting alone having conversations about what's not working out as women, men don't hear that conversation. They're not part of that conversation. And what we don't allow them to do then is understand some of the subtlety about what we're talking about. And I just wanted to take one example of stereotypes and the way in which stereotypes pervade in the kind of work that we're all involved in. I thought it was interesting to give you an example from a non-gender field to see how it can work more broadly. I recently had a case where my client was an Afro-Caribbean Rastafarian. It was actually on fact a very straightforward case indeed. He was offered a job by a local government body, and a strange set of circumstances transpired. The offer was withdrawn. And social worker. And if the offer was withdrawn, it effectively meant he wouldn't be able to work as a social worker again because he would be blacklisted by a government body. It seemed to my mind that the reason that the offer was withdrawn was because of a perception that he was aggressive or that he was taking drugs. And we were rather stunned to hear the defendant local council claim that there was no such thing as a stereotype of associating black men with violence or Rastafarians with marijuana. And we were absolutely stunned to hear a white middle-class judge sitting in the most diverse borough of London say that, well, he accepted that the local government's position was that those weren't stereotypes because he had no evidence of it. And we sought to appeal it, and various steps were then taken. Now, one of the reasons I was so struck by that was because in other cases that I run, judges are very, very willing to accept the stereotype of women because they now understand that stereotype. So if you hear people in the workplace or in education or wherever it might be say, oh, you know, she was hysterical, she was too emotional, she didn't really want to come back full-time after having a baby, judges are now alive to those stereotypes and they are able to take what's called judicial consideration of those kinds of stereotypes. So we have moved forward over the last 20 years or so of equality legislation to a position where many judges are very aware of the stereotypes relating to women. We've had to work our way through to get there, but they're not so aware of stereotypes relating to minorities or religion or other aspects. And that leads me to talk about why it's so important that we have a diverse bench. Because it would have been extraordinary had a black judge made the same finding. Because it would have been in his or her life experience that these are common stereotypes. Easily, you type it into a Google search and there'll be something immediately that comes up. It's part of your lived experience as a black man in the UK or as a Rastafarian in the UK, just as so many factors are part of our lived experience as women. And we expect our judges and our bench to be able to reflect that. And the only way that can happen is, first of all, if there are enough advocates coming through the system who are women, who are from those minorities, and then if enough of those advocates reach senior positions, and then enough of those advocates become judges. I'm incredibly fortunate to have her on the Judge Sapnara with us today. But let me tell you, even from the perspective of the UK, I don't come here today to say we've got it right. We haven't yet. We are still on a long journey. Recently, bar council figures have shown that the number of women in private practice at the bar has actually dropped in the last decade rather than raised. It doesn't look like it when you look at the complexion of the profession, because especially amongst the juniors, it looks like there's an awful lot of women. But what seems to be happening is there is a stubborn gap towards the top of the profession. About the age women have children, they start to drop away, and you don't have still very many QCs, senior counsel, and you still don't have the same numbers that one would be expecting. It's getting better, slowly. But to give you an example, last week, week before last, a female judge who comes from an employment and equality background was sworn in to be a High Court judge, and there was literally celebrations, crazy celebrations, amongst many of us at the bar who had worked with her as a colleague and then as a judge for many years, because we felt like this was progress. So I wanted to leave you on that note to say that nowhere has got this right yet. Scandinavia are making probably bigger steps than most of us, but nowhere has got this right. But you do see change. We are seeing change. I have seen change through 20 years of working in the profession in this field. But it takes hard work and commitment, and it takes having everybody on side. And the last thing I would just like to say is on the Me Too movement. It has shaken up the profession across the world. Helena referred to the IBA, various surveys and studies done, and there was an IBA report which showed the prevalence of sexual harassment within the profession internationally. What has been eye-opening in the UK, and this is the very last question I wanted to address this morning is, what about equality in our own profession? How do we go out and fight for the women around us if we don't have it in our own profession? And that is why there is an obligation on us to speak up and to stand up in our profession when we see things are going wrong. And what's been extraordinary is that in the last 2 years since the Me Too movement began, we have seen a conversation happen in the bar in the UK and in the law profession in general, where people are openly now talking about their experiences as female barristers and as female solicitors, which has never really happened before. Not in this way, not so widely. And it's been extraordinary to note that even though there's been Bar Council rules, if you like, about sexual harassment and policies on harassment and policies on discrimination, notwithstanding some years of those policies, notwithstanding an Equality Act which prevents in law such policies, the very real problem in our profession is that because it's been so male-dominated for so long, and because it's a brutal profession in so many ways, and for you here in Pakistan, I know, far harder than it has been for us in the UK, but because of those combinations, we're expected to tough it out. Don't complain, bite your lip, and get on with it, and eventually you'll somehow make progress. And the truth is, that is what a number of women did for most of their careers. And the great change that has come, well, I can't say it's a great change, but a significant change that has come as a result of the Me Too movement is that junior women now feel they shouldn't have to put up with it. And that is a real change in 20 years of practicing a profession. And so I would urge you all to embrace the opportunity that the Me Too movement has also given us to talk about the inequalities in our profession and to confront judges who don't confront them for us. On a very practical level, we don't have to be talking about sexual harassment. We don't have to be talking about the extremities of sexual harassment. We can be talking about the day-to-day issues in our practice that make life as a practitioner difficult for us. If you are told, as happens to us sometimes on a weekly basis, at 4 o'clock when you're expecting court to rise, and you're told by the judge, actually I'm going to sit till 5:30 this evening, any problems with that, Ms. Jolly? Or you're told, actually I'd like to see written submissions overnight on this new topic that I haven't heard about. No problem with that, I assume, Ms. Jolly. And you have to get home to children, to your caring responsibilities, we've got to collect them from nursery, whichever else it might be, or actually that you might simply be exhausted by the fact that you have 18 other briefs that need doing that tonight. We have to find a voice as a profession to say that sort of bullying and that sort of apparently neutral conduct, I've asked the man the same, so why should it be any different, actually has a disproportionate impact on many, many women at the bar. And we need to be in a profession where we're able to say, it's much harder for the juniors, so the impetus is on us as the senior members of the profession to say, no, Your Honour, I can't do it. With the greatest respect, I can give you submissions by tomorrow evening, but I can't do it by tomorrow morning, whichever it might be. We have to lead by example. That's much easier said than done, but we can't make changes around us more widely if we don't do it in our own profession. And that's the thought I'd like to leave you with today. Thank you very much for that.
It's a pleasure to be here in Lahore on the eve of the second ASMA Jahangir conference. I want to begin by thanking those that have worked so hard to organize today and say thank you to Sulima for inviting me. I feel a little bit of imposter sharing the floor with 3 people that I really, really admire, and it's a real honor. I have not been to Lahore since 2013, when I had the privilege of staying with ASMA whilst working on the thorny issues of religious freedom and forced religious conversions. I was honoured when later that year ASMA came to Doughty Street Chambers and gave a speech with myself and Jeffrey Robertson and QC. Her whole life, ASMA put the most vulnerable people at the forefront of her work, and it's therefore only fitting that we focus some time on the most vulnerable people that we represent in court as trial advocates. The treatment of vulnerable witnesses in civil and criminal trials is obviously a huge subject, and inevitable that I focus on a particular aspect of it to offer some practical tips for best practice. In my own work in London, I work predominantly in the family division of the High Court and also with people who lack mental capacity in the Court of Protection. One of the most significant challenges that I've faced is how we go about the cross-examination of children. It's not something I was ever trained to do during my advocacy course, the bar vocational course that it used to be called. It's something that you very much have to, or I've had to learn whilst in practice. Now, I'm obviously not an expert in the law here in Pakistan. I'm speaking to you as a member of the Bar of England and Wales and venturing to give advice on best practice. One immediate thought you may have is that I appear to you today as an outsider. And that's true, but much of the guidance on best practice is based on learnings from our jurisdiction in England and Wales when we've got this issue wrong. As Schona was saying, we have not always done things the best way. In criminal law in particular, we have got things badly wrong in the past, when lawyers have made the headlines for the grossly inappropriate way they've cross-examined children in court. But we are improving. And over time, we've developed practical things that we can do to improve. I'm going to be speaking mainly about the civil or the family courts. There has slowly built up some useful guidance from judicial and other professional working groups, and now a solid line of jurisprudence. Much of the practical thoughts I want to offer this morning are derived from that jurisprudence. The issue of whether a child should give evidence in court should be considered at the very, very earliest opportunity. Indeed, I would say that should be flagged up at the very first hearing where you think it may be an issue in a case. With the principal objective of achieving a fair trial, there needs to be a balancing exercise between the following primary considerations. The first, the possible advantages that the child being called to give evidence may have to the determination of the truth. And secondly, the possible damage to the child's welfare from giving evidence. In other words, the risk of harm to the child from giving evidence. So what sort of factors should we have regard to? Well, from the UK experience, may I suggest the following. Number one, the child's wishes and feelings, in particular the willingness to give evidence. Number two, the child's practical needs and abilities. Three, the issues that actually need to be determined in the case. Four, the nature and gravity of the allegations, the source of the allegations. Five, whether the case depends on a child's allegations alone. Six, the quality and reliability of the existing evidence. Seven, the quality and reliability of best practice interviews from ABE interviews from police. 9, the nature of any challenge a party wishes to make. And 10, the maturity and vulnerability and understanding and capacity, competence of the child. It's not just the age of the child alone. Now, thought, in my humble opinion, should also be given to the specific risks arising from the possibility of the child giving evidence twice in criminal and family proceedings. And what we have now in England and Wales between the last 10 years is for it to be normal for there to be linked criminal and family directions hearings, so that can be managed by the same judge. Now, I'm speaking about children giving evidence. in court, but actually one of the things that we should think about at the very start is whether that needs to happen and whether there's an alternative way one can deal with it, whether you can put questions in writing. Once a decision has been taken that a child is going to give evidence and is going to be questioned in court, then you should factor in steps to improve the quality of the child's evidence and minimize the risk of harm. At the earliest opportunity, and in any way before the hearing at which the evidence will actually be given, the following matters I think should be considered. And I've condensed this into 5 practical considerations. Is live cross-examination appropriate at all? The use of other special measures, and in particular video links and screens. Advanced judicial approval of any questions proposed to the child. So the judge can check how you are going to articulate your questions. The need for ground rules to be discussed ahead of time between the lawyers and the judge. And just very, very basic things that you can sometimes overlook, as like the need for breaks. Practical considerations before the hearing starts. Advocates, I think, should go and meet the child, should introduce themselves. It can be very strange if the child hasn't been part of the case before, it's been a long, complicated, ongoing case, and you suddenly enter a courtroom and there's lots of strange faces sitting in court. Go and introduce yourself, say who you are. The child should be told how the video link works, if they're going to be given evidence by that, in that way. If there's a particular issue and sensitivity around it, a secure exit where they can come into the court and leave the court without seeing anybody that they don't want to see. Now I want to move on to the actual cross-examination of children. And again, this is an issue that I wasn't ever taught to do, and I've had to learn on the job. And I've derived some of this from our guidance from the Supreme Court, and some of this from my own sort of meandering experience. But I've condensed it into 10 points. Number 1, be at the child's pace and consistent with their understanding. Repeat names and places frequently. 3, ask one short question, so one idea at a time. 4, let the child know the subject of the question. 5, follow a structured approach, signposting the subject. 6, avoid repetition. Avoid overly adversarial, what we could now call in the UK Old Bailey style cross-examination. 8, avoid restricted choice questions. 9, be slow and allow time to answer. And 10, test the evidence, not try and trick the witness. Now, all advocates have a responsibility to manage the questioning of a child witness fairly. The ultimate responsibility for ensuring that the child gives evidence in the best possible way will be for the judge, for the tribunal. It should set the expectations for the advocates at the start. The importance of targeted advocacy training, both written and oral advocacy, in this area cannot be emphasized enough. Despite the general training I received, nothing prepared me for how challenging this area can be. So in conclusion, I want to say the following. Human rights at its very heart is about compassion, not something overly legalistic. Children and those with mental health difficulties are the most vulnerable people in our society. So think carefully about the wording of your questions and the manner in which you put them. Of course, we operate in an adversarial system, But being adversarial doesn't necessarily mean being inappropriate with your questions. It doesn't mean humiliating somebody. You can apply your mind to properly putting your client's case without resorting to any of that. Thank you.
Thank you, Zimran. Khawateen Hazrat, we will have a tea break for about half an hour, and after that we will have the closing remarks from Her Honor Judge Khatun Sapnara. Thank you.
करवा लेंगे वो देंगे
Khawatinu Hazrat, we will now begin the session again. The next session are closing remarks from our Honored Judge Khatun Sapnara. Justice Sapnara is a circuit judge in England and Wales, and she is authorized to act as judge of the High Court. She has worked for many years as a barrister in both family and criminal matters. She has sat as a judge for many years in one of the busiest courts in England, and we are very honored to have her here to give her closing remarks to conclude the morning session. Thank you.
Assalamu alaikum, everyone. Good morning. Thank you very much for inviting me to speak. I'd like to thank Sulema Jahangir and her family. It is an honor and a real privilege not only to be here and to be asked to address you, but to do so at a conference in the name of the great and incomparable Asma Jahangir. I had the pleasure of meeting Asma on 2 occasions in London, and in fact in 2000 my former chambers made her an honorary tenant, and that is an association of which I am immensely proud. It seems to me that the incredible range and depth of subject matter that is going to be addressed at this conference is a fitting tribute to the really serious and important work that she undertook with such tenacity and courage. At a time when the rule of law and the protection of fundamental freedoms and human rights are under pressure around the world, this conference, it seems to me, is of critical importance. I cannot tell you what joy it brings me to see this room full of women, and in particular Muslim women also. And really, I'm not here to preach to you about how we do things better in England and in the jurisdiction of England and Wales. You'll have heard from Schona earlier that we have our own challenges that we have to still overcome, and that there are comparable issues that we need yet to address. But hopefully, working together in this sort of forum, we can make real progress. Now, the work of the family court, and before I go on to that, I want to perhaps to tell you that I was born in Bangladesh, which was of course East Pakistan then, a long time ago, and I was born in a village in Bangladesh, and I was not from a privileged background. We arrived in England, and I attended state schools. My family were not well off, they were not educated, and on top of gender issues, as a Muslim woman of a black and ethnic minority background, there were additional challenges that I faced. And really, I only mention all of that because I really empathize from the discussions we have had at this conference and around this conference of the issues that you face as well. And just to say to you, you know, if we can make the progress we have in England with still challenges, and if I can have achieved what I have, then you can too. All right? Now, the decisions that are made on a daily basis in the family courts actively engage human rights. The High Court Family Division hears cases of the utmost gravity and decisions literally around life and death. And you may have heard of the recent case of Tafida Rakib, the little girl who required life-saving treatment and eventually, despite challenges by the medical profession, who said that actually there was nothing more that they could do to treat this girl with very serious brain damage, and her parents had been allowed to seek further treatment for her in Italy. So they're the kind of really serious issues that the family division deals with. And the cases we deal with involve very serious physical injury, sexual abuse, and death of children and adults. They contain international issues of jurisdiction and where and with whom a child should live. We deprive young people of their liberty when we incarcerate them in secure accommodation units, for example, when they are beyond parental control. They are a danger to themselves and others in society. And, for example, when they are involved in drug-related gang violence or religious radicalization. We routinely hear cases involving harmful cultural practices, including forced marriage and female genital mutilation. We also deal with cases involving trafficking. We impose limits on the freedom of the press to report on the details of the case in order to prioritize the welfare of a child and his or her anonymity so that they can grow up without everybody knowing every detail of their private lives. And one of the most draconian decisions that a family court judge can make is to sanction the forced removal of a child from the biological family and sever that relationship in law after very detailed and painstaking evaluation of the evidence. We are bound to try to rehabilitate children to their natural families where we can, so long as that is commensurate with their welfare and that their safety can essentially be guaranteed. And it's in that arena that a lot of families who are from the Pakistani diaspora in England or are otherwise of Pakistani heritage come before the family courts. While I will concentrate on some of the gender issues in this case, I think it's quite important for us to recognise that it is the intersectionality of disadvantage operating in the case of BAME communities which often complicates cases and compounds the problems that are experienced otherwise by the majority community. And nowhere is that more focused, I think, in terms of power imbalances in our society currently. And justice doesn't operate in a vacuum. The context we are dealing with at the moment is continuing gender discrimination, but when you have a Muslim woman who is poor, who doesn't have economic power, who faces discrimination on multiple levels from within their own minority community as well as from the majority community, it's not difficult then to see how their lives are very significantly impacted upon. Now, I want to sort of start by talking about a case that I was instructed on when I was a very, very junior barrister many moons ago. It wasn't the most high-profile case I had undertaken. It didn't involve a celebrity. It didn't involve really very complex law. There were no real legal novel points to argue. But it remains for me one of the most important cases that I was ever engaged in. And it also served as a salutary lesson in the importance of the principle of access to justice, as well as equality. So I was already engaged on another complex case at court. I received a call from my clerk in chambers to say, could I represent an applicant seeking injunctive relief within the domestic violence legislation in respect of domestic abuse perpetrated against her by her husband. They had married in Pakistan. He had brought her over to England to ostensibly live together as husband and wife. They have 3 children, all under the age of 12. On a daily basis, he subjected her to the most brutal violence, physical, but also verbal and psychological and emotional. She was locked up in the home all day, cooking and cleaning, not allowed out, and not allowed out without him accompanying her. If that were not bad enough, what he then proceeded to do was to entertain lots of different women in the next room, engaging in intimate sexual relations, which were audible to her and her children. And that, as you can imagine, serves to reinforce the degradation that she experienced. Eventually, one morning, just by luck, she managed to escape because he had left and forgotten to lock the doors securely. She ran out onto the street and with her limited English was able to prevail upon people to try and help her. She was then referred to the police, who had very good connections with the local women's refuge. And this was a women's refuge that was specifically designed to assist women of her background. It was a refuge that I was later the chair of, called Ashiana in East London. And they helped support her through the legal system, in helping her to get rehousing, etc. And you know, in an age of austerity economically in our country, it is always those provisions that go first in terms of funding. And it is absolutely critical that those support lifelines are actually continued to be funded in our country. Anyway, she arrived at court looking the browbeaten, abused, exhausted woman that she was. And she was also very embarrassed to reveal the details of her experiences. She was in an unkempt state, as were her children. They had just escaped in the clothes that they were in. They smelt, they hadn't been able to wash. And I fought quite hard with the judge to get some of the injunctive relief that he wasn't really very readily going to yield to on this emergency, one-sided ex parte application. And after the hearing, I was about to return to my main trial, and for some reason the solicitor's representative who had attended with the woman at court left her. And I was very concerned about how she was going to get back to the refuge. So I took her and the children and made sure that they had something to eat, put them on the bus, spoke to the bus driver so that they would be returned to a familiar environment. And, you know, when I got home, I just wept because I thought, well, you know, as a lawyer, I did my bit, but really, what use was that to her? This bit of paper that I'd managed to secure for her, how was that really going to change her life, given the very desperate situation that she was in? Well, the answer came 6 months later. I was in chambers, engaged on another case, and a colleague of mine knocked on the door and said, there's somebody here to see you who would like to say hello to you. And in came this woman, very glamorous, very beautiful, and I was at a loss, and I didn't know who she was. And it was the same woman. It was the same woman. And what that bit of paper did for her is to empower her and to enable her to take some autonomy over her life and be able to exercise that. And she was rehoused with the children, and she was actually in chambers in consultation with a barrister who was representing her in the divorce proceedings. She had custody of her children. Because he's so abusive, he wasn't going to be able to have unrestricted, unsupervised contact with the children. So they were protected. And she was going to get her fair share of the matrimonial assets and money in order to enable her to stand on her own 2 feet. So that is an example of what having access to the justice system can do for you. She had learned to speak English, she was driving, she was taking driving lessons, and she was really creating a new life for herself. But she was publicly funded, she had access to legal aid. Without it, there's no way that woman would be able to afford the finest representation in the country, because you can have the best of barristers on legal aid in our country. And in domestic violence cases, forced marriage cases, female genital mutilation cases, we have fought very hard to make sure that the state, whatever other cuts it was making, retained and ring-fenced money to enable women like that to be able to access the justice system. And when, so she had that, she also had, as I say, the support of a voluntary sector agency, which is in part reliant upon funding from government. Now, I am sure that a majority community barrister would have fought, and they do routinely. My brothers and sisters in law, they fight very hard to secure justice for people. That is the common cause that we are all engaged in, the pursuit and delivery of justice. But did it make a difference to her to have representing her a BAME lawyer, a BAME barrister instructed by a BAME solicitor? Well, I think it did, because it enabled her to have the confidence to feel that she would be understood, and therefore enabled her to actually give her authentic narrative in relation to all of this and give informed instructions. And when those women come before the court, does it inhibit them to see people who don't reflect her? Does that impact upon her ability in court, perhaps never being subject to a male gaze, to have to give evidence among a room full of people where there is no one who looks like her that she can identify with? I am sure that it does impact upon her. So this gathering is something really very unusual. I'm not used to it in London. And very recently, I was overjoyed to come into court and see the front row of advocates, all BAME women lawyers. And it was a moment that I thought, we're making some progress here. They were all brilliant, brilliant advocates, each fighting their own case, all very, very different. And you know what? I think it made a difference to them as well to see someone like me on the bench. All of those communications I received, direct and indirect, through body language when I walk into court, from litigants, from advocates, from members of the jury, and court staff, who actually face quite a lot of discrimination within our court system. That's something that people don't pick up on readily. I am sure it makes a difference to them, because I know if I were in their position that I would feel, I think, that I had a stake in this system rather than feeling marginalised. So representation actually, it seems to me, really matters. And changes in the law frequently comes from grassroots activism. So I'm very pleased to see here also academics and women's activists, because you make a difference. We're all in partnership in trying to identify the deficits in the law and to see how we can plug those deficits together. And in England, it is women's organisations like Southall Black Sisters whose campaigns led to parliamentarians taking up women's causes and being better informed in terms of how and what changes they were going to seek to make to the law. And it's not just black and minority specific interests that these organisations have affected by the work that they have done. Southall Black Sisters brought about a change to the law in relation to provocation as a partial defence to a charge of murder. They supported and campaigned on behalf of Kiranjit Ahluwalia, an Asian woman who set fire to her husband in May 1989 after years of suffering abuse and brutality, over 10 years. She was charged with and convicted of murder and imprisoned to life sentence with a tariff of 12 years. Her lawyers at the time advised her that there were no grounds for appeal. Southall Black Sisters first of all, made an application to the family court to transfer the custody of her children from her mother-in-law to her sister, and thereafter supported her in prison. And that's something we frequently see in the family courts. Women that have had to flee in order to save their lives are then penalised within our justice system. First of all, by the fact that the status quo, which is her leaving her children within the extended family home, and obviously it's the paternal extended family home, while she tries to get back on her feet. The courts then routinely decide, well, the child is okay and functioning well, and their needs are being met, albeit emotional needs in terms of seeing the mother are not being met, and therefore that will be the status quo until we get to a final hearing. But that works to discriminate against these women, because the longer that goes on, the more difficult it is to change those arrangements. So it's essential that when a woman flees in that situation, that she is supported in taking her children with her. And I say her children, because obviously the family have rights as well, the father has rights, but she is almost invariably the primary carer of that child. And so it's really important that she is assisted in that process. So Southern Black Sisters then persuaded the Court of Appeal in 1992 that the defence of provocation should be open to victims of domestic violence, and that the particular requirement of a sudden and temporary loss of self-control had been traditionally interpreted in ways which excluded the experiences of battered women. And it recognised the notion of cumulative provocation, and also accepted that as a matter of law, the time lapse between an act of provocation and the fatal act need not be construed as a cooling off period. Instead, the court accepted that time lapse could be seen as the boiling over period, and it was a matter that could be essentially left to a jury to determine at trial. And what it highlighted was the inherent male bias of the criminal justice system in that regard. And that, that affects all women. The appeal itself was allowed on the ground of diminished responsibility, and at her retrial, her plea of guilty on the basis of diminished responsibility led to her sentence being significantly reduced and to her walking free from court because of the time that she had already served. And so, after further campaigns by women's groups, the law of provocation was abolished in 2010, and a new partial defence to murder termed loss of control was introduced in recognition of the fact that reliance on the factor of suddenness was male-biased and outdated. And at the same time, factors relied upon by men for killing women, such as sexual infidelity and a desire for revenge, traditional excuses deployed by men who killed, would no longer be grounds for reducing murder to manslaughter. It also cannot be just coincidence that it took a female president of the Family Division of the High Court to preside over a number of cases in the year 2000 to rule that the exposure of children to domestic violence was significantly harmful to their welfare. To see or hear their mother being abused in that way was significantly harmful to them. That decision itself was based on a research paper produced by two very eminent medical experts, doctors Dania Glazer and Claire Sturge, and it had a radical impact upon the law relating to children, whether in private law, custody and access disputes, or in cases where the state intervenes in order to safeguard children, to prevent them being harmed in the care of their parents. And so we have had specific legislation in relation to domestic violence for over 40 years now. 1976 it first came in, and we have been incrementally trying to improve it, extend its scope. And so the concept of controlling and coercive behaviour as a criminal offence was brought in at the end of 2015, and within the family law arena we extended the categories in which domestic violence injunctions could be secured, even where you were not married, not even cohabiting, but were in a significant duration relationship, and also as between other family members, such as an adult son who lived in the household with a mother who was assaulting her on a regular basis. And sometimes these issues are compounded, of course, by factors such as poor mental health, as well as substance misuse, drugs and alcohol. And so it is quite clear that that sort of engagement with a range of people is what brings about the changes in the law. In terms of the Forced Marriage Civil Protection Act, dated 2007, came into force in 2008. I was actively involved in that. And it was inevitable, really, in some ways, because I was a barrister who had been practicing for many years, representing women and children as a specialism within the domestic abuse context. I was chair of Ashiana, the only dedicated forced marriage refuge in the country, and I was sitting as a part-time judge, so hearing and adjudicating on those cases, and I am a Bangladeshi Muslim woman in my heritage. And so what I want to say to you is that in a legal system where the judiciary in our country are still from a very narrow pool, usually white, older men who are privately educated, incredibly privileged backgrounds, tend to make, I am not representative of the judiciary in England and Wales. And so there was a value, an added value, that I brought to the table in relation to that, in terms of making sure that the law that, and it was a real privilege, it's a rare privilege for a lawyer to be involved with parliamentary draftsmen in order to draft legislation and to really shape it and create it on an informed basis. So, you know, we brought in these new measures, which was, for example, that the application could be made by a third party, not just the state, but someone that they that is known to them, perhaps a boyfriend who's left behind when the young woman is abducted to Pakistan or Bangladesh, wherever, to be forced into marriage. That the orders we made, they were extraterritorial in jurisdiction and effect, that it was unlawful to do it in England or to bring a person over to Pakistan to force her into marriage. And you know, the kind of cases I've dealt with as an advocate and as a judge, you know, have involved young women being duped, taken through passport control, drugged so that they are not able to voice their opposition, brought over and forced to marry at gunpoint by their own father, with mothers that are complicit in that, sometimes because we have quite a high level of consanguinity within the Pakistani community that we see in England. And so it becomes very, very confused, and it's really difficult fact-finding exercise when you have the immediate family of the woman lining up to give evidence against her in support of the perpetrators of the abuse because of issues of sharam and izzat. And of course, an English judge doesn't necessarily understand and thinks perhaps that is going to undermine and affect her credibility. So what we did is make sure that there was mandatory training of all judges in England and Wales that were going to hear these cases through the Judicial College. And I was absolutely adamant that that was going to have to be part of what the government funded when we enacted this legislation, as well as providing support to advocates. One of the concerns I have about advocates in England and Wales is that they don't actually need to be accredited or even undergo specific training to deal with, as Zimran pointed out, with children as witnesses, to deal with domestic violence, much less forced marriage and female genital mutilation cases. And in fact, the judiciary receive greater level of training than the advocates do. And I think there is a case actually for saying there ought to be a system of accreditation when you undertake this vital and sensitive work. The forced marriage protection orders were really effective. They exceeded our expectations. Hundreds of women and children and young men. You know, there are young men that are forced into marriage. Very often they are gay men whose sexuality brings them into disrepute, and they are victims too. We have to remember that. And we have saved a lot of lives, because you only get one chance, actually, sometimes, to save a life in those circumstances. And there's been mandatory training for the safeguarding agencies, the police, medical professionals, and education professionals as well, to make sure that we have some coordinated effort in trying to protect people. The forced marriage protection orders that are routinely now, in my court, we will have female genital mutilation or forced marriage case on a weekly, if not a daily basis, as some element of the cases that we are dealing with, and that is where most of the cases are heard, because of the identity of the diaspora and the litigant base within our jurisdiction. And they are afforded, the special measures in terms of vulnerability. And the Act was really the culmination of High Court judges using the inherent jurisdiction of the High Court and wardship proceedings in order to recognise vulnerability, not just in children, but recognising that women, irrespective of their educational attainment, their financial wealth, that they can still be victims of domestic violence and forced marriage, and recognising that vulnerability in them. And I have to say, the people that developed that law were actually white men in the family division, and that really reflects what was said earlier about the fact that we all have to work together in partnership in order to be able to make that sort of progress. Now, as I say, it's been 100 years, as you've heard Baroness Kennedy say, 100 years since women were allowed to become lawyers in England and Wales. And, we haven't got everything right. When I came to the bar, it was a time when women weren't actually allowed to wear trousers in court. I mean, this is 1990, and women weren't allowed to wear trousers, and that has changed. So you can see that we're all evolving at different levels. Now, the people of Pakistani heritage that come within the child safeguarding processes, what I have to tell you is that we go to great lengths to try and understand the pressures that impact upon people, not just in terms of socioeconomic disadvantage, but also to understand the religious and cultural context in which they operate. And the problem had been historically that we didn't really have structures in place to deal with these sorts of issues that were raised by the settlement of immigrants from the new Commonwealth. And there was a tendency for there to be a liberal confusion about multiculturalism and reluctance to interfere in families because people might be seen to be racist and discriminatory. And that allowed harmful practices to fester. Our society doesn't have a written constitutional code, but it subscribes to the concepts of equality under law and the rejection of invidious discrimination. The European Convention on Human Rights, Human Rights Treaties, the Equalities Acts, and the common law provide standards for lawmakers and judges, but they do not create a coherent concept of British citizenship and integration. And weak enforcement of equality laws allowed patterns of inequality to become entrenched in the name of cultural diversity. And in the words of the junior minister from the Home Office at the time that we were setting up the working group to deal with the legal gap in being able to address forced marriage, said, cultural sensitivity is no excuse for moral blindness. And that remains, I think, a principle that we can all actually adhere to in order to bring about change. And cultural and religious considerations were often incorrectly used to justify unequal treatment of individuals, but they don't excuse harmful practices, but they can give us an explanation and a context. And equality at the end of the day means ensuring that everyone is treated with fairness and respecting and recognising the needs of individuals. And we cannot achieve equality without an equal commitment to diversity, which recognises and takes into account the value of people's difference and the contributions that that makes to community cohesion, ultimately. And to enable and empower people to realise the full extent of their talent and their aspirations, because otherwise it's a loss in terms of the resources available to us in our society. Now, BAME families have experienced discrimination previously. When they come to our court, they have real issues of trust, which is understandable. Lack of trust in state and professionals. That is coupled with what we find to be an unusually high level of denial that there has actually been any abuse perpetrated. And that compounds the difficulties. You know, a Pakistani man who has abused his wife such that she has left his home faces shame within his community, and he needs to explain why this woman has left. And very frequently, well, always, because I've not come across a case in which they've held up their hands and said, yes, it's because I treated her so appallingly and I'm so sorry about it. Usually, it's because they try and justify their actions. So frequently what we have to deal with when we're undertaking fact-finding exercises and trying to assess credibility, because sometimes it's just her word against his with no other corroboration, you have to look to see why she left. And the excuses and the allegations compounds the abuse that she's already suffered, because what she would be accused of, I'm sure you're familiar with it, is sexual impropriety, infidelity, mental health problems, that she doesn't have agency, therefore other people are whispering in her ear, and she is being used as a puppet to manipulate and bring shame on the other extended paternal family. And so, even though in our country there are all these issues around, integration, it's instructive to note that families who are said to subscribe to social segregation, and one of the things that everybody is overly focused on is the dress that women adopt, whether they wear burqa or niqab or hijab. And in those cases where children who were obviously beyond their parental control were lured to Syria to join ISIS, but those families who were said to have been at odds with the institutions in our country, interestingly, looked to the British state authorities and institutions to help them, the police, social services, and our courts, to assist in returning their children. And these parents often, but not always, engage in active, demanding, and necessarily intrusive processes during proceedings which scrutinise their private lives. And they even engage in therapeutic intervention, which, despite that being an alien concept to them, a bit of sort of social and cultural anathema to them, they engage in those processes. And my view really is not what you do, it's not what you say, it's how you do all of that. And for people that feel marginalised already, it's very important for state institutions and professionals to engage with them in a way that is respectful, not judgmental, and that engages them in a way that is designed to do the job that professional is there to do, whether it's to elicit a narrative or to put, for example, charges to individuals. And so, that's the kind of backdrop that we've been dealing with. When we deal with children in safeguarding from Pakistani families, what I want you to know is that we go to great lengths, actually, to make sure, for example, they have interpreters in court, they have access to legal aid, irrespective of means. It's not means tested. The fact that the state is intervening and that your Article 8 rights are actively engaged means that we have to treat all of this with proportion. The decisions we make have to be proportionate and necessary when nothing else will do. And we also need to make sure that people's Article 6 rights are protected, that there is fairness within the proceedings, and therefore the interpreters come in. If there are learning difficulties, we have communication specialists that can ensure that the person understands what is being asked of them before they give answers. And we also fund, very often these days, but we don't have enough, experts and professionals to assess risk, assess people's acceptance of the concerns, and then to see whether they can demonstrate that they can make sufficient changes in order to warrant the children being returned home. And the answer is not necessarily always actually just to take children away, because black children in the care system, and there's a disproportionate number of them within our care system, suffer all sorts of other issues that arise within that system. And therefore, if you can return a child home safely, undertake educative work with the family to enable them to understand and change their practices, which they might have understood to be the only practice that was relevant and appropriate, then you bring about changes. The one last thing I want to quickly talk about is the protocol we have with Pakistan in international child abduction cases. This was a protocol which I learned only last night had actually been drafted in the Jahangir household. So Baroness Butler-Sloss had come over. She was the president of the family division at the time, and you will appreciate that children across borders and abduction, whether from England to Pakistan or Pakistan to England, is a real problem. And the children who have been removed or later retained unlawfully in circumstances which might amount to a wrongful interference with the other parents and other older children's rights and interests means that that comes within the scope of the bilateral agreement that we have with the Pakistani judiciary. And the rationale behind it, you'll appreciate, is that decisions concerning children should be determined in the state of their habitual residence. And it is very difficult, if not impossible, for the left behind parent to participate either effectively or at all in proceedings in the other state. And therefore, it's really important to know about the existence of that protocol and also the role that you might have as lawyers in providing expert opinion and also representation of either the children or the abducting parent in this country, or the left behind parent, as it might be, and to be aware of the real practical difficulties that we can encounter. But we really value the work that's done through the international liaison judges to give effect to our orders, to provide us with information, for example, about what the last order might have been made in your courts, and for you as lawyers and experts to undertake those inquiries locally, to tell us about documentation and their authenticity, and also to tell us whether or not the relationships between individuals given rise to circumstances of abduction are as we have been told in sworn statements in court. So we've got quite a long way to go in our own jurisdiction because of issues around Brexit, etc. We have not had an opportunity for the domestic abuse bill currently to go through the stages in Parliament, and we are very concerned about that because the removal from scope of domestic violence cases, the victims, the applicants always have legal aid, the respondents do not, and frequently in those cases we were finding that the perpetrator of abuse was at the outset cross-examining the victim, and as you can imagine that's re-traumatizing and further abuse. So then what we did is stepped in with judges making sure that we have the questions in advance. These are litigants in person, so it's very, very unwieldy to make sure that we rule on what questions are relevant and we pose the question. And that raises all sorts of issues about judges descending into the arena of courtroom and how appropriate that is. And now what we're looking for with the domestic abuse to bring parity between the family court and the criminal court to make sure that there is a state-funded advocate that can conduct that cross-examination without the victim having to be cross-examined by the perpetrator. So I'm going to bring that to a close now. I hope that's been helpful to you. Thank you very much.
Friends, can I just before you hear, I just want to say to you, it was so important that Judge Khatun Sapnara was there to lead the way on the business of forced marriage in Britain. It wouldn't have happened without her. And she's been very, it really was revolutionary. And I hope that you might think about whether such law might not be a useful addition to your own circumstances, and that there might not be some exchange that could be done on that learning, because we all had to learn and she led the way.
I want to thank all our distinguished guests for their speeches and for traveling here, taking the time out from their busy schedules to come and spend some time with us here in Pakistan. We do not have many opportunities like this, and we are very grateful. I also want to thank all our participants who have come, traveled far and wide from across Pakistan to be here in solidarity with us. I think it speaks volumes about the importance and seriousness of this subject, which is the empowerment of women. Sadly, Pakistan was rated as the second worst country in the world for gender gap in 2018 by the World Economic Forum. And one of the comments made by some of our guests was that they didn't see a lot of women. They're not very visible on the streets and generally, as for example, other South Asian countries like in India or Bangladesh. And I think that's true, but I'm glad that at least in the courtrooms, I see a lot more women now than in the past. When my mother started work as a lawyer, I was the only girl in my class of 40 girls whose mother worked. But I see now in Pakistan, a lot of those girls who were my class fellows, a lot of them work now. So I'm happy to see that progress. I can only hope that it gets better with time. Today at this event this morning, somebody said to me, you know, I'm very happy to be here in your mother's name because your mother opened a lot of closed doors in this country. And I think we are here together for this event to open closed doors and to open closed minds. As my mother used to say, we women are the last colony left, and we have to decolonize ourselves together. Thank you. I will now request you to, there will be lunch, and then there will be the afternoon session which will focus on the criminal justice system in Pakistan, which will be across the hall, in the hall across. The afternoon session will start at 2:30. So may I request you to be on time, and we will now break up for lunch. I'm sorry there wasn't much time for questions, but you will have time over lunch to speak to our distinguished guests. Thank you very much.